My name is Neil Dornbaum. I'm a partner in Dornbaum Peregoy. I've been practicing immigration law exclusively now for the last 25 years, and our firm's practice is limited to immigration and nationality matters with a special emphasis on employment-based immigration. I've also had the pleasure of serving as the program chair for the last 10 years on advanced employment-based immigration issues for the New Jersey Office of Continuing Legal Education. Employment-based immigration is difficult to understand simply because there are so many different options that one may be able to pursue. There are currently 5 different categories, EB 1, 2, 3, 4, and 5, and each of those categories have subcategories under the employment-based processing. Simplistically, though, employment-based processing breaks down into 2 choices. Number 1 is going through the expedited processes, where the United States government will expedite the processing of permanent residence for certain individuals. Those include individuals of extraordinary ability, those individuals who are considered outstanding researchers or professors of international renown, individuals whose work is in the national interest of the United States, corporate executives and managers who are being rotated into the United States for an international assignment where they have been employed overseas in excess of 1 year, investors who are going to make a substantial investment into the United States, and also individuals who are healthcare professionals or religious workers. The bulk, though, of individuals who will be processed for permanent residence will go through the labor certification process. The labor certification process is also referred to as the PERM processing. This process is a 3-step process. The first step is an employer indicating that they cannot find able, willing, or qualified Americans to do this job. And basically they are going to make a submission to the United States Department of Labor, 1, proving that they have engaged in a good faith recruitment effort to locate a U.S. worker and was unsuccessful, and 2, that they are going to be paying the prevailing rate of pay to this individual and therefore not bringing in cheap labor. The application for alien labor certification is complicated. There are a number of different areas that you must be familiar with in processing a labor certification. The form itself is complicated. There are restrictions on the wording and the business necessity for the requirements that the employer sets forth. And processing times can vary from anywhere from 1 week from submission to a decision to up to 3 years on the same application. Once a labor certification is approved by the United States Department of Labor, the second stage processing is the filing of an I-140 petition. The I-140 petition requires the employer to prove that they have the ability to pay the wage for the foreign national, and that the foreign national has the necessary education and experience necessary to perform the job duties. The third and final stage is the filing of an application to adjust one's status to that of a permanent residence here in the United States through the I-485 application, or they can complete the processing through consular processing at an American consulate overseas. If you would like to discuss further your eligibility to obtain permanent residence via employment in the United States, we would ask that you please reach out and schedule a consultation with us. Thank you.